You're listening to Amplify, a YWCA Enid podcast. I'm your host, Courtney Dennis, Executive Director of the YWCA. This podcast creates space for conversations that matter. Each episode will explore advocacy, survivor support, community issues, and the work being done to build safer, stronger communities. Through honest stories, expert insight, and meaningful dialogue, we hope to inform, empower, and inspire. We're glad you're here to join us in this conversation. Today, our special guest is someone doing incredibly important work in our community. Bre Johnson, a legal aid attorney housed right here at the YWCA Enid, who's been with us since November of 2023. Bre works closely with individuals navigating difficult and often overwhelming legal situations, helping connect survivors and community members with resources, advocacy, and legal support they may not otherwise have access to. Bre's work sits at the intersection of justice, safety, and empowerment, and we're excited to have her here to help us better understand the role legal aid plays in our community, the barriers many people face within the legal system, and why access to support matters so much. I'm super excited to be here today with Bre Johnson. She is our legal aid attorney that's embedded here on site at the YWCA. We're so glad to have you, Bre. Welcome.
Thank you. I'm so excited to be here.
Today, we're going to be talking about a lot of different things related to the legal system, protective orders, custody, just the whole process is extremely overwhelming for anybody, especially somebody going through crisis. So I think first, let's start with, Bre, would you tell us what is legal aid?
Yeah, absolutely. So legal aid is a free legal service. We do civil cases. That can range from family law, housing cases, employment potentially, Social Security. We cover all different kinds of things. I generally handle just the family law and domestic violence cases, but we do a wide range from advice all the way through trial and litigation. We are also a nonprofit, so there is no charge or any fee for survivors or anybody else who is a client of ours. Clients are eligible based on an income basis. We typically use like a 200% poverty level to establish whether or not someone qualifies for legal services. However, there are also exceptions. So I do tell people that if you think you could qualify, I would recommend go ahead and apply for it, because we can take domestic violence into consideration. We can take into consideration bills and expenses. But yeah, we provide free civil legal services to people in the community that need it.
And I know you stay very, very busy. Actually, my favorite story about you, and I'm gonna share. So when Bre first started, I was showing her around the office, welcoming her, talking about what kind of caseload I thought she would have and what the need is in the community for legal services. And I remember you telling me, oh, I'll only be here a couple days a week. Well, that is definitely not what happened. You are here every day of the week. Yes. And work very hard, stay very busy. So I appreciate you being on site at the YWCA. I appreciate the partnership with Legal Aid Services because it's so needed. That's obviously evidenced by how busy you are. And there are just many barriers to somebody receiving legal services. So I'm very glad that we're able to knock down some of those and have you accessible here at the YWCA. Let's talk about the cases that you do in a little more depth. So I know a big part of your work is protective orders, and that means there's a lot of information that goes into a protective order. So can initially you walk us through the process of getting a protective order? What is it and who qualifies?
Yeah, absolutely. So protective orders come from a statute in Oklahoma called the Protection from Domestic Abuse Act. It is a very lengthy statute. It's very technical, so I won't get into all the details of that. But there are certain qualifications. In general, it's going to be someone who is a victim of a crime. There are some crimes enumerated on what the court typically will look at, things like harassment, stalking, domestic violence, rape, those kinds of cases, your typical violent crimes. However, it can technically be a crime victim in general. Protective orders are there to protect from an imminent threat of harm. So it can be after harm has already occurred and trying to prevent further harm, or it can just be if there have been threats or if there's a pattern of escalation. Protective orders can hopefully help come in and have a court order that will prevent that behavior from happening again. So there are a lot of different terms that can be included, and there are a lot of different provisions that a lot of people don't think about that can be added to protective orders as well.
Absolutely, and I'm glad that you said threats, because I think many people think that an incident had to have already happened for you to
Yes.
receive that. A couple years ago, I know Oklahoma put into statute that stalking can now is eligible for a protective order. Can you talk about that? Because that's very different in terms of what is needed to receive that protective order.
Right. Yeah. So the process, I'll get into that a little bit more. So when an incident occurs, or if there's a threat, it can be stalking, it can be online harassment. There are a lot of different things that can qualify. A person will generally either call the police and make a report, or they can call a local shelter, they can call the DA's office. There's a lot of different opportunities to be able to start a protective order process. I do recommend filing a police report, although it's not always necessary. Generally, the statute only requires a police report if it's not a family or household member that you're filing against. And if it is one of those people that's not within that category, then you are going to have a police report. You're going to have to take it to the courthouse, and you will have to have that documentation. But if it is someone that you're filing against that lives in your household, or that's a family member or a previous dating relationship, you do not need a police report. I think it's the easiest place to start, though. It adds some credibility, and it, I think, streamlines the process a little bit, because the police can actually get you started on getting your protective order, whether it be after hours or during the day. They can contact your local DV shelter, like the YWCA, who has people that can help get
Yes.
protective orders started.
We have a court advocate on site 24/7 that works very closely with you to
Yes.
be able to provide that. And we also work very closely with the district attorney's office.
Yeah. Yeah, and it's a really good streamlined process. So generally people will fill out the protective order before they get to me. And then once it does get to me, that's when we start the court process. So a person will be given a court date if they're given an emergency protective order or not, to start an immediate protection. And then they will bring that petition to me, and we'll get started. I'll enter an appearance into the case. We'll go to the court date, and then we'll provide some testimony and evidence asking why that protective order is necessary. I will say that there are some different circumstances where that hearing may not occur immediately. It's generally a pretty quick process, usually within a couple of weeks. But if there's a family law case, or if there are children involved, then it can be a little bit lengthier. Cases can be consolidated.
How long can an individual receive protection from a protective order? How long do they last usually?
Yeah, so protective orders under the statute, you can have a fixed term for up to 5 years. So the court can do a lot of different things within that. They can do a 6-month protective order. They can do a year, 2 years, kind of whatever the survivor is asking for. But they can only do a fixed term for up to 5. And then you can always come back and get it renewed. They can also do a permanent protective order. However, those are a lot harder to get, and there are some certain circumstances that will allow for those, but it's not always. So, for example, generally it's going to be if someone doesn't follow court orders, if there's a history of repeated violations of those orders, whether it be a protective order or something else, if they have a violent felony conviction, if there's a patterned history of domestic abuse, those kinds of things. And then there's also this little catch-all at the end of that says that if the survivor does testify about enough reasons for why a permanent protective order is necessary, they can actually get one. The court has a little bit of discretion for that.
Very good. That's great information to have. Now, when you receive a protective order, have you filed charges against that person? Is that now a criminal case? Can you explain the difference?
Yeah, that's a great question, and that's one that I get a lot from clients. So starting a protective order process does not immediately start a criminal case. It is going to be a civil case, so it will be separate from the criminal justice system. However, it's something that we call a quasi-criminal case because it can have criminal implications.
Okay.
So it can be on their criminal record, essentially, even though it's a civil case. But like I said, it doesn't automatically start a case. Now, if you do want to start a case, again, I go back to that police report. That's going to be that first step. And then the police will then hand that to the DA's office through an affidavit, and the DA's office will decide whether to pursue charges. And the victim does not have to participate in that, but it's unlikely to move forward unless they do. And same thing with protective orders. I mean, it is kind of an involved process where the survivor is going to have to be in court and giving testimony and evidence.
How do you work with your clients going through that? I mean, that is extremely stressful. You're already going through a crisis situation. You're in survival mode, and now you've been asked to testify in front of your abuser because they have rights too in this process.
Yeah.
So how do you help people kind of navigate that?
It is a really difficult conversation to initially have with clients. That is something that we have to break down in detail. I generally will have people come to my office, meet face to face, and we'll go through the ins and outs of what to expect from the time that you walk into that courthouse to the time we walk out. I want to ensure that clients are well prepared and that they know what to expect. Because, yeah, a lot of people don't know that you're going to have to testify in front of your abuser. And that is sometimes a deal breaker for people. And
Sure.
so I try to prepare them as best I can. And we practice testimony prep. I ensure that, again, they know what the courtroom's going to look like. If it's a younger client, for example, I've had children involved on a protective order, we can go to the courthouse and do like a practice run and just show you what that looks like,
Good to
get you
know.
familiar with the situation. But yeah, it is a very traumatizing process. And sometimes protective orders aren't always the best case for everyone. You know, it can set off abusers and make them even more angry. There's options in family law cases, if there's a divorce case or a custody case, to potentially do a mutual restraining order, which is kind of similar. So, yeah, it's not always the best fit for everyone, but it is there to try to prevent further harm.
I'm really glad you mentioned that because I think there are a lot of myths surrounding protective orders. And just because you've received a protective order for whatever length of time, that doesn't necessarily mean you're safe. My opinion, not a legal opinion, is that the protective order will give you more of a leg to stand on when you need to call the police if they show up, if they violate that protective order. Talk to us about what are things that somebody could do to violate a protective order.
Yeah, so I agree with that, and that's something that I hear a lot is that a protective order is just a piece of paper.
Right.
That's something I hear a lot, and at the end of the day, yes, it is. You know, that's not going to prevent someone from hurting you if that is what they are intended to do. But it is there as a hopeful attempt to at least sometimes scare the abusers a little bit into recognizing that, hey, this is a reality and has some implications to it and that you need to stop this
Right.
behavior.
And there's a paper trail on you
And
now.
there's a paper trail.
I think one of the most important things that we tell survivors, and I'm sure you do as well, as you've mentioned, is to document.
Yes.
Document everything.
Yes.
File that police report so you have that backup.
Yes.
Get the protective order so you've established a pattern once you need to go into maybe custody or divorce or whatever
Absolutely.
they may be
Absolutely.
facing.
And as to the violations, so there are a lot of different ways that people can violate a protective order. And I think one of the most common ones that we see that not everyone knows is a violation is going through a third party. So,
okay.
yeah, so we of course know that a violation is going to be if they show up at your house or if they show up at your work and they try to harass you or call you or text you on their own. But if they go through a third party and say, hey, pass this message along to this person, that can still be considered a violation. And if an offender does violate a protective order, the procedure is typically that they would get arrested. There'd be a police report. But again, that's on the survivor to document and report. So it is kind of creating another barrier for survivors in the sense that they do have to document things. They have to keep their evidence because there really does have to be a little bit more proof to a violation, I would say, than there does even to a petition for a protective order. So for a petition, you can go in and testify, and you don't necessarily need hard physical evidence.
Okay.
But for a violation, police generally want to see some kind of either documentation through screenshots or a camera. So I usually recommend for my clients to take pictures if they see his car driving past or her car driving past. Document, dash cams. Those are other things that I've recommended for clients. But yeah, there's a lot of ways to violate, and I would suggest that if there's a violation, immediately call the police. That's going to be your first step, and then the police will again give that affidavit over to the DA's office, and the DA will decide whether to pursue charges.
Gotcha. If it does enter into a criminal case, what rights do you have? So I mentioned on our first episode that there's generally frustration among survivors and those of us that have navigated the legal system with the offender having sometimes more rights than the victim.
Yeah.
So talk about the rights of the individual that's filed the protective order. What if that eventually turns into a criminal case with that person? What does that look like?
Yeah, and that's a really good point because that's another thing that a lot of survivors don't really know before walking into the courtroom is that realistically I feel that the legal system is built for defenders. It really is. That's what our Constitution allows for is rights to fair trial, right to a jury trial, right to be able to, get the documentation from the prosecutor, all those kinds of things. So it is very it's very protective of defendants. And victims often do fall through the cracks. I mean, there are a lot of barriers and there are a lot of things that are broken about the system. And there are only so many things that we can do on the civil side, which is really frustrating because I've had that happen. Victims of a crime have protection and rights under Marcy's Law. So Marcy's Law, as you know, is an Oklahoma law that came from a really tragic case, but has allowed for a lot of incredible rights for victims to have, but not a lot of people know about it. And that's rights to things like knowing when court dates are, being able to go to those court dates. You know, even if it's a criminal case and you're not testifying, you still have a right to be able to go and make a victim impact statement, have a little bit of say about, you know, a plea deal that's being offered to the defendant.
Right.
So
Sign up for the victim notification system,
yes,
also known
on
as Vine.
Yeah.
So those are really important pieces for somebody to feel like they're regaining control over the
Yes.
situation and are empowered to have the information. So I think that's
Yeah.
really important.
Yeah, and like I said, it's kind of a situation where, again, some of those rights have to be invoked. So it is, again, on the survivor to have to know about those rights. And so that's one of the things I do is I prepare a pamphlet for all of my new clients, and I give them a folder, and I say, okay, I'm going to give you a lot of papers. So I'm going to give you this folder that you can keep all your court documents in one
Sure.
place. And I always put a pamphlet in there about Marcy's Law and their rights as crime victims, because whether or not there is a criminal case, you know, they need to know about that. And realistically, I should not be the first person telling them about it. Usually law enforcement will do that if there's a police report. But I want to ensure that people do know about that because it's something that's not talked about enough.
Right. And in a moment of crisis, when you're working with the police, I mean, they may tell you that, but will you absorb it?
Right.
Who knows? So I think that's great that you provide that information. There's so much. Even those of us that work in this, there's just so
Yes.
much to know. And as we were preparing for this, I told you I'm not even sure some of the answers to some of these questions. So I'm so glad to be here, and I'm glad you're here to educate everyone.
Yeah.
I think it's very unique, and why we have partnered with Legal Aid Services, as have many other victim services agencies, so that those individuals can receive the trauma-informed care, receive some of those wraparound services. Because you mentioned that you had worked closely with our counseling department to streamline referrals, and I think that's really important that they're connected to all the other wraparound services that they may need. And also, you know, our court advocacy, working with you to go with the victim and just be, I mean, you're going to be up doing your duties as an attorney. And so to have an advocate there with the survivor, just to sit there and offer emotional support is really important. So all of those pieces are really important to empower a survivor to, you know, receive justice and feel confident in doing that.
Definitely. And it's been a really great partnership. I mean, I can't speak for Legal Aid, obviously, but being here every day, it's a great opportunity, like you said, for survivors to get wraparound services, because when a client comes in to see an attorney, and this is something I've always said, they're having the worst day of their lives. I mean, most of the time. No one comes to us for happy reasons.
Right.
And so, you know, I would never want to have to hire an attorney. It's not fun. And going through the legal system isn't fun, and it's confusing. It's re-traumatizing having to go through and know that you're the one responsible for having to document things, even though you've lived it, you know, and feeling the guilt of leaving sometimes. Like, there are so many things that we have to even get over discussing in that very first meeting. But it's been great because I can assess, you know, hey, do you have a counselor? Have you been able to talk to somebody, you know, about this? And I'm able to do, a referral process with one of our amazing counselors here. And I've had clients that may even need to do some additional safety planning than what even I can offer. And so I connect them with an advocate if they need a place to stay. That's one of the things when we start talking about family law cases, it can be really dangerous to file if they're in the same house. And so sometimes the survivor needs to find somewhere to go. And the YWCA has been a great resource for that.
That's a great point.
Yeah, and I've had court advocates come with me to trials, and because it can be so emotional. And you're right, I'm up there, I'm trying to navigate all the legal aspects and the procedural aspects, and it's so nice that survivors, even if they don't have family or friends here, that they can have somebody go with them, because it can feel very isolating.
Definitely. You can feel very alone, very exposed,
Yes.
very raw, very vulnerable. And like you mentioned, we put a lot of the responsibility on that individual who's already navigating an abusive situation, and how to get out of it, and how to protect their children, and you know, how to continue to function while all of that's going on, as well as hopefully escape it eventually.
Yeah, and I try to tell my clients from the get-go, too, that your only job is to tell the truth. And my job is everything else. And so that's something I try to explain to them, especially when it comes to trial and things of that nature, is that your only job is to tell your story. The judge doesn't know your story. He doesn't know what you've been through. And your only job is to provide that information to him. And then my job is to handle every other aspect of that. I try to take precautions with, I walk clients to their cars. I walk them into the courtroom if they need to, into the courthouse. We can get an officer to do an escort to their cars for safety if that's a concern also. We can stagger leaving and arriving times at the courthouse with the abuser. So there are steps that we try to take that I try to tell them about up front so that they can feel like they're a bit in control of the situation and that, they've been lacking control for a long time. And they're trying to navigate the shame, the guilt, the not knowing what the legal process is. And so that's why I try to say, like, your only job is to tell the truth. Leave everything else to me.
Great point. You mentioned all the emotions that come with filing a protective order, leaving an abusive relationship, getting a divorce that we'll talk about here shortly, custody, things like that. And you and I were visiting about, the grief that somebody may feel. Like, how did my life end up here? How am I going to live without this relationship? Like, whether or not you were in an abusive situation, I mean, which they are when they come to us, I mean, you're still losing a big part of your life and grieving a family you thought you were going to have and what your life would look like.
Yeah, and you're losing a part of yourself. And that's something that I see a lot is survivors struggle to find independence again. They, like I said, a lot of times, if you're in this situation, you've lacked the ability to make decisions on your own, trust your gut, even financially provide for yourself, because financial control is a huge part of domestic violence that a lot of people don't talk about. And even going so far as, educating judges on that. I have to explain to survivors that, hey, just because there was not a physical incident does not mean that you are not a victim of domestic violence. And I get a lot of people that are in my chair crying and apologizing and thinking that they're not worthy of being clients because they don't think that it's as bad as someone else has had it. And that's always really heartbreaking because, we have this innate reaction to characterize our trauma compared to other people that we know.
Right.
But every single person that is in my chair, I try to ensure that they know that their trauma is no less than anyone else's.
Yeah.
And that a lot of times they don't even know what they've been through because it's so normal for them.
Right.
And so, yeah, there's the grief of losing a relationship. There's the financial hardships of trying to find if you've been stuck being a single mom or a single parent, in that relationship and not being able to work, stay at home. There's the grief of leaving pets. That's a big thing.
Sure.
Finding shelter. I mean, there's so many so many barriers that people have to face, and they are in true survival mode.
And one huge benefit of legal aid services is obviously that they are free.
Yes.
And correct me if I'm wrong, but the only cost that they may have to pay is like court filing fees.
Yeah.
And that's very minimal. And I know you've had instances where you've requested waivers of those fees in different situations. So I think that's one of the biggest benefits because you're right. They have been financially controlled in most cases. And how do you seek help if you have no resources? So
Exactly.
I think that's really powerful, and a really powerful message that I want people to hear is that this help is available for free here at the YWCA.
Exactly. Yeah. And that, I mean, that economic barriers are huge for divorce cases, protective order cases, all of those kinds of things. And notably, protective orders are free. So you will not have court costs at all for a protective order. Unless, of course, you're doing it fraudulently. But, I mean, that's not the case, Yeah. And
that's a whole nother topic.
And fraudulently does not mean that you don't get a protective order. It just means that you were doing it for the wrong reasons.
Right.
So, or you don't have a basis. But even if you don't get one, there still usually are not costs to protective orders. Now, to a custody case or a divorce case, there is a couple $100s that you usually have to pay for filing fees. However, with legal aid, I always file what's called a pauper's affidavit. So that's where we ask the court to waive those court costs. The client will have to just fill out some financial information, and then the court will assess that and decide whether or not to waive the cost. And realistically, I mean, there have been maybe one or two cases that I've had that weren't waived. So they generally are in my cases. But yeah, you don't pay us anything. And that's the great thing is that you can ask us for advice. You can call and ask us for advice. We can go all the way through trial, and you're not going to have to pay a dime to us.
That's huge.
It is huge. Yeah. And even people that apply for legal aid don't know that sometimes. I get to them and they're like, okay, how does this work? And then I explain during the retainer process that, yeah, you don't pay us anything. Even if we go all the way to appeals in the Oklahoma Supreme Court, you don't pay us anything. So it is, I really love that legal aid is able to do that through grants and funding.
What a blessing. I know you're funded through the Victims of Crime Act grant, which also provides the YWCA with funding for a few key positions. So I think that's really important that The federal government has seen that there is power behind the VOCA grant. We are saving lives and healing individuals and helping them find justice through that.
Yeah, definitely.
What is the most surprising thing about the protective order process that you hear from clients?
I think we've kind of touched on some of it, like having to testify in front of your abuser is a big thing. I would say also that protective orders, it can go quickly, which some people aren't necessarily prepared for. So especially if you don't have an attorney, if you don't have an attorney that's going to come in and do all the evidentiary questions and procedural and things like that, I mean, you could have your protective order granted within a couple of weeks. So it kind of just depends. But I think that some people are a little bit hesitant of like, oh my gosh, I filed this and now I have to go to court next week.
Right.
So it can be a fast process. But like I said, it depends on if there's a family law case or if there's children involved. I will say that one thing that's kind of frustrating, but that I've seen happen as well, is that if children are involved, the court's a little bit more hesitant to grant final protective orders. They're kind of difficult to get because the court usually wants to see some kind of family law case.
And you can include children and pets
Yes.
into a protective order. So I think
Yes.
that's also really important for people to know. But like you said, it does make it a little more complicated to receive that. And I think another thing to note that you just mentioned that's extremely important is that you don't have to have an attorney to file a protective order.
Absolutely.
You can reach out to the YWCA. Our court advocate can help you with that. The district attorney's office can help with that. So there are multiple ways to do it. You just have a advantage having an attorney navigate that process with you.
Yeah, definitely. And I think some other things that are kind of surprising is that when I say the process moves pretty quickly, it's even when you get the protective order. So when you're filing for that, there's going to be a judge that's either on call if it's after hours, or there's going to be, you're going to go to the courthouse and have an advocate take that petition to the judge, and they're going to make a determination right then and there on whether an emergency protective order is granted. And so you could have protection from that date until your court date, if that is granted. And that can get complicated when the person that you're filing against lives with you, or if they're a spouse.
Right.
So that's something to also consider, is that the police will, if there's an emergency protective order granted, the police will likely be removing that individual from the home.
Right. And they will be notified. You can't do it in secret.
Yes, they will be notified. And so that's where I go back to it's not the best option for every single situation.
It can be very dangerous.
It can.
We've definitely seen some situations where people have filed and the violence has increased. And
Yeah.
so that's really something that you need to visit with your attorney, with an advocate about
Yes.
your specific situation.
Yeah.
Bre, you provide a multitude of legal services. Let's shift into talking about family law. Specifically, how does an abusive situation factor into family law?
Yeah, so it really depends on if there are children involved, how intricate the case is going to be. So we do two different kinds of family law cases generally. We do divorce cases for if you're married, or we do like custody and paternity cases if it's unmarried but there are children involved. So in divorce, you're going to divide up assets, you're going to divide up, child custody, things like that. And I think that one thing that surprises people, and that can be kind of difficult to navigate when abuse is involved, is that there is a presumption of joint custody equal time when it comes to child custody. So it is, again, there's a theme here. It's kind of on the survivor to relate why that is not the best avenue and in the best interest of the children. So that's how it factors in. But again, like I said before, the judge only knows what you tell them.
True.
And so you do have to testify in front of your abuser. You can bring witnesses. You can bring evidence and exhibits if you have them. Those are always great and helpful. But your testimony is also enough. You can just share what you've been through, and that can sometimes be enough.
So speaking of both parents having essentially equal rights to visitation, can somebody legally leave with their children if they're in an unsafe situation? What are the legal implications of doing that?
That's always a touchy subject and a touchy question, because I do get that sometimes as well. And my advice is you do what is best for your family. You know what is right for you. And so there are legal implications, but it's not going to automatically have you, get arrested and come back to Oklahoma or come back to whatever county you're in. There are a couple different scenarios where, again, it can be in the best interest. Sometimes you have to leave. You can go to a shelter, you can go somewhere, stay with a friend, you can cross state lines if you have to. There are procedures that the other person can file to try to get the child back, but that doesn't necessarily mean they're going to do that. They could file what's called a writ of habeas corpus. They can file for emergency custody. I always just tell people that if you want to leave, do so before filing anything, because when you do file, an injunction gets slapped in place. And that is a huge thing to discuss. And we could talk more about that.
Yeah, can you elaborate on that?
Yeah. So an injunction goes into place when you file a family law case. And what that means is there are certain things that you can no longer do when a court case is started. So you can't shift around assets. You can't sell things that are marital property. You can't hide or secret away the children. You can't take them out of school, take them across state lines. All of those things kind of shift into place as soon as you file. So what I tell people is, if you are wanting to move in the near future and you think that it is safe enough for you to get away for a little bit and be able to move, then I would suggest doing that before you file, because that gives you a little bit more leeway. As long as there's not a court order in place, you have a lot more flexibility with it.
That's great information, and I think a very big piece of safety planning. So thank you for sharing that. Do children have to testify in those court cases if there are kids involved? I think that's probably a huge point of apprehension. We talked about related to protective orders, that you didn't realize you had to testify in front of your abuser. Like, that's so much more, could be more traumatic to the children to have to do that. So what does that look like?
Very much so, yeah. And that's a question I get a lot too. And they don't have to testify. So first and foremost, and I will say that generally the court doesn't favor children testifying because it is such a traumatic process.
That's great to know.
Yeah. And I mean, you don't want kids to have to go in and testify in front of one parent, and well, in front of both parents, but testifying about, yes, being put in the middle. And so they don't have to testify. However, there are certain circumstances where you really do kind of want their testimony, and sometimes kids want to be involved. So if a child is 12 years or older, there's a presumption that they're old enough to give a preference. They don't have to be 12 if they're of sufficient age and maturity and intelligence, but that's kind of the cutoff of, like, the court will take that into consideration if the child wants to talk about it. There are also some other protections in place that you can do what's called in-camera testimony, which is where the child can go back with a judge and just talk in private, or the attorneys can be there. It just kind of depends on the circumstances. Or you can appoint what's called a guardian ad litem to be an attorney for the children.
Now, what if you haven't left the situation yet? Your spouse is still living in the home with you. Can you file? What happens in that instance?
You can file, but I would recommend waiting. So I will say with legal aid, we generally don't file cases until you're out of the home, just because it's a safety concern. We do not want to have the abusive person served with paperwork and then take that out on you right away.
Right. You both be in the same home, and all that tension is right there.
Yes. So we'd recommend waiting, if possible, until you are separated. You can be separated for months, even years, before filing for divorce. And it can still be things like considered separate property if you do, end up acquiring things after the separation. So realistically, your safety is paramount. And I personally and most attorneys will not want to file something if that puts you at risk.
So on the flip side, what if you have left the relationship and you don't know where your spouse or ex-partner is? Can you still get a divorce? Can you still file custody? How do they participate in that?
Yeah, that happens a lot. Because again, you want the safety at the forefront. So a lot of times people will leave and then they're like, well, I have no idea where they are now. And so that's another myth that I see a lot in the legal system, is people don't know that you can get a divorce without any involvement by the other person. The other person can even show up and say they don't want a divorce, and you can still get a divorce. So you can do things like serving via publication, which is in the newspaper. You have to get court approval for that. It's just a process. But you absolutely can still get a divorce even if you don't know where the other party is. You just have to make good efforts to try to find them.
So the petitioner really has the rights in that situation.
Yes.
They can't come in and say, well, I'm not signing this. I don't want to do this. Just to be obstinate. So that's really good to know. You mentioned myths about domestic violence cases. What are some others?
There's so many things, because as we've talked about before, if you haven't been through this process, you're not going to know what that looks like. And so I will say it's not near as fun or dramatic as TV is. That's a big thing. There's not going to be a jury sitting in the room when you have a divorce case. It's realistically going to just be me, the other attorney, and then witnesses and parties and the judge. So that's a big thing. It's very quiet and isolating. It's not as dramatic as we see on TV. Another thing would be, again, having to testify in front of that person and having to go through all the nitty-gritty details. It can be really re-traumatizing. I do try to settle cases. I have an ethical duty to try to mediate and settle cases before we go to trial. And if we do go to trial, ensuring that you're prepared for that. But I mean, there are so many myths about, people that, again, oh, my husband's not going to sign divorce papers. He said he's not going to ever allow me to get a divorce. You can still get your divorce, and that's
You
so
have the
important.
power.
You
You're
have the
empowered.
power. Yes, that's a great way to frame it. And because a lot of people don't know that, and that's why people stay, is because they feel stuck. And so, I mean, there's a plethora of things that we could go through, but I think that those are some big things to touch on.
What if they start to become hesitant? You filed, oh no, can I rein this back in? Can I pull out of this? Do you have an option once you filed even protective orders to stop the process at any time?
Yeah, so if you're the petitioner, if you're the one that filed that divorce case or custody case, you can always withdraw it. Now, I will say you may face some court cost at that point. Court may not waive it if you're pulling the case, but you can decide to withdraw that application. And now I will say if the opposing party has filed a counter petition, then they will also have to withdraw theirs. Because again, each party is entitled to a divorce or custody case if they want one. So if they've also filed within your case, then they'd have to withdraw it as well. And then with a protective order, yes, you can withdraw it at any time. You can dismiss it at any time. There's no cost associated to that. And there's really not a repercussion to it because, again, they're not for everybody. And sometimes you just need them for the cooling off period. But it can, if it becomes a habit, potentially make it more difficult in the future to get a protective order, especially against that person.
And you mentioned mediation versus actually going to trial and going through that court process. What percentage of those you work with do mediation versus actually having to go to court and testify and kind of open that whole can of worms?
Yeah, so that's really up to the client. Like, I try to give them the power in knowing that, hey, you are in control of the situation. If you want to go to trial, we go to trial. But I will say that I do have an ethical duty under, my bar license to try to settle and mediate cases. And so generally what that process looks like is if there's an attorney on the other side, I talk to them. If there's not, then I talk to the opposing party individually. And just basically going back and forth of like, okay, what are you seeking? Here's what we're wanting, trying to get some negotiation. And then we can go to mediation, which is a neutral third party who can help us kind of sit down at a table or in separate rooms if there's a protective order or a safety concern, and have just a discussion about how we want to divide things. Because a lot of times there are things that we can agree on, even if it's not everything. And that can kind of shorten what trial needs to be about. So I would say that most of the time we do get cases settled, but there are those instances where we just can't reach a mediation and we have to go to trial. But again, if a client wants to go to trial, they have a right to do that.
That puts you in a precarious situation, I know, because I've obviously experienced it with you working here, of having to be the one that communicates with the opposing party.
Yes.
And I know that has caused some safety concerns here for you, for us. So that's really interesting to know because I think people don't really understand that. We're not just representing the victim if they're not going to find their own representation legally.
Yeah, and that can create a lot of difficulties too because it's a difficult road to navigate in the sense that, you don't want to be seen as being a mediator because you are there advocating for your client. And so it's kind of a tightrope to walk of explaining to that pro se individual who's representing themselves like, hey, I don't represent your interest. I am here solely to advocate for my client, but I do have a duty to talk to you because you're not represented and try to get something sorted out.
What is considered, because I know domestic violence has a very specific legal definition, what is considered domestic violence in terms of like what you're presenting and this is why somebody should maybe have primary custody, there's this domestic violence situation, what is the criteria for that?
Yeah, I would say that we've come a long way in destigmatizing what domestic violence is and what it really means because while there is a legal definition, it doesn't encompass everything. And so I try to paint a picture to judges or to opposing parties or whatever I need to do to explain that, hey, all of these pieces, the financial abuse, the sexual abuse, the coercion and control, emotional, verbal, physical, all of those things are considered domestic violence. And I do think, like I said, that we've come a long way in relaying that and that I think judges have come a long way in understanding that. And so I always point to all of it. But I will say, too, that even if there's domestic violence in the relationship, we don't have to touch on it in trial if the client's not comfortable with that. So, for example, in family law cases, I file under incompatibility. And
Okay.
so you don't have to prove domestic violence, but it can be there as testimony if you need to for children or whatever else is involved.
But if you do file under reasons of domestic violence, that you have to prove that
Yes.
in a court of law.
Yeah,
Okay.
and generally, like I said, we almost always file under incompatibility, but the client has the choice on that. And they can choose. Sometimes they don't want the domestic violence to come in if there's no need for it, like if it's just a property dispute, or if they don't care if there's joint custody or whatever the situation may be. That's kind of the power that's given to the client to decide on whether they want to get into that or not.
I think that's a really important point that we keep driving home, is that the survivor has the choice. You have the
Yes.
autonomy. You are empowered to make a decision about how you want to navigate your situation, and also the legal process in its entirety. So I think that's a really important message. What's one thing that you wish every survivor knew before starting this process?
I think one of the hardest things is that it is a process. It can be very time consuming, and there's a lot of stuff that goes on in the background. It depends on, like I said, if there's kids or property. Divorces can get done really quickly if there's no children involved and no dispute really. But if there are children, or if there is a lot of property dispute, it can take years. And it's
They're very
unfortunate.
lengthy.
It is, yeah, and it is unfortunate because you're finally at this point where you want to separate from that individual, and you want to start over, and you want to be on your own and start your life anew. And then you have to keep getting reminded that, hey, this case is still lingering, and it's really frustrating because even after it's done, you can still come back and modify. I mean, like it's not set in stone depending on the circumstances of the case, and so I think that's one of the most difficult things is maybe adjusting expectations of what that process looks like. And as a client, you have the right to be on me, calling me and making sure that I'm doing my job. And
I know they do.
They do. Yeah, they do. They keep me on my toes. Yeah, for sure. But it's good for accountability, and it's necessary. And again, it gives some of that autonomy back of knowing that, hey, you're in control of your case too.
And someone is advocating for you.
Yeah, someone is advocating for you, but there's a lot that happens in the background. It's a process, like I said. There's deadlines, there's due dates, there's a whole pre-trial conference, like scheduling. I mean, it's not something that can happen overnight, which is really frustrating. But I think that's a key thing, is just knowing that as long as your attorney is doing their job, it will get done. It's
Right.
just a process.
And just really setting those realistic expectations.
Yeah.
What else should our audience know about family law or any other types of cases that you've worked with?
I think another thing too is don't be afraid to ask questions. That's a big thing. I get a lot of clients that come in and just they don't know the process. They don't even know what questions to ask sometimes. And so I personally think as an attorney, it's my job to help fill in those gaps and even,
Exactly.
kind of expect, hey, do you have a question about this? But don't be ashamed to ask. Even if you think it's basic, even if you think it's something that's quickly that you can Google. That's another thing. Don't rely on ChatGPT for legal advice. I've had that happen, and that's been a mess. So there are a lot of intricacies, but just know that you have the right to ask questions. You have the right to say if you're not comfortable with something, and like I said, your only job is to tell the truth and to let that speak for its own.
I love that.
Yeah, and whatever happens, it happens. I mean, and sometimes it's really hard to accept, but a judge is going to make their decision. And sometimes I feel like that helps a little bit for survivors in the sense that the weight is off their shoulders because it is out of your hands. All you have to do is tell your story, and then that individual is going to decide what happens. So it does take some of that responsibility and pressure off, I think. But yeah, I mean, you're in control, and it's something that you may not be used to, but you should exercise it.
Absolutely. Most importantly, how does somebody in need get a hold of you? How do you start that process? When should they reach out? You mentioned that people can call with questions. So I'm going to assume that at any point they can reach out if they have questions about legal, but how does that work?
Yeah, so I would always suggest that, I mean, even if you're just thinking about it, even if you're thinking like, hey, I might need to file for divorce, I might need some help safety planning, I would recommend reaching out as soon as possible because I can help you talk about, that injunction, talk about separating assets, what you can do before you file. There is an application process, so you can apply online or you can apply over the phone. Online is legalaidok.org, which I'm sure we can put in the podcast somewhere to make that accessible. And then there's also a phone number. It's 888-534-5243. And you can call that anytime for an intake specialist to be able to talk to you and get the details of your case and be able to put you into our system. Then we have to do a conflict check, and we just have to make sure that we can take your case, we staff it, and then, one of us will reach out. So I would say as soon as you can. If you know that you have a court date coming up, definitely get on that as quickly as possible. Even reach out to me here at the Y. I can sometimes fast track things a little bit, but yeah, it's we're here to help, and like I said, there's no harm, and even if you just have a couple of questions, you can always call us and just say, hey, I need some advice.
Right. It's really not an intimidating process.
Yeah.
I really commend how comfortable that you make individuals when they call and know that we are accessible and can help. And like you mentioned, they can also call the YWCA office, and we'll connect you with all of those numbers and resources.
Yeah,
So,
absolutely.
Bre, thank you so much for being here today. I think this was so valuable and just a topic that many don't know. And like you said, don't know what to ask. So thank you for filling in all of those questions. And I really appreciate you being here and all you do for survivors.
Yeah, thank you for having me. It's been a great time, and I really appreciate everything that the Y does, and I truly appreciate the partnership. I think it's great for survivors.
Us too. Thanks so much for joining us today, and we'll see you next time. If you or someone you know is experiencing domestic violence, sexual assault, or stalking, you are not alone. YWCA Enid is here to help you. You can call or text us 24/7, 365 at 580-234-7644 for confidential support, advocacy, and resources. You deserve to feel safe, supported, believed, and heard.